Hello everyone. I welcome all of you to the 24th session of the course Energy Law. In today's session, we will discuss Selected Energy Charter Treaty Arbitral Awards. Let us quickly recap what we have covered in the previous session. In the previous session, we discussed the Energy Charter Treaty's substantive protections covering fair and equitable treatment, full protection and security, the prohibition against unreasonable and discriminatory measures, the prohibition against unlawful expropriation, and the umbrella clause. In today's session, we will discuss Selected Energy Charter Treaty Arbitral Awards. The awards that we discuss today include Ioannis Kardossopoulos vs. Georgia, Nykomb Synergetics Technology Holding AB vs. Republic of Latvia, Petrobart Limited vs. the Kyrgyz Republic, Amto vs. Ukraine, and Plama Consortium Limited vs. Republic of Bulgaria. Let us examine the first case, Ioannis Kardossopoulos vs. Georgia. The dispute concerns allegations that Georgia has breached its obligations to Kardossopoulos under the bilateral investment treaty between Greece and Georgia, and also under the Energy Charter Treaty in respect of Kardossopoulos' interest in oil and gas concessions in Georgia. Let us examine the factual background. In 1992, an American company, Tramax International, entered into a joint venture agreement with Georgia's state-owned oil company, Synergetics, to develop and operate oil and gas pipelines. The joint venture Georgian Oil Products Company was formed to modernize and operate the pipeline network connecting Azerbaijan to the Black Sea. Ioannis Kardossopoulos, a Greek investor, held an interest in the venture through Tramax. In 1995, the Georgian government terminated GOPC's rights, effectively expropriating the concession. Subsequently, Georgia granted the rights to a new consortium, the Caspian Pipeline Consortium, excluding Kardossopoulos and Tramax. Let us examine the claims by the investor. The claims include alleged unlawful expropriation of investment, violation of fair and equitable treatment standards under the Bilateral Investment Treaty and the Energy Charter Treaty, failure to accord full protection and security to the investment, and denial of justice and breach of legitimate expectations. This was a dual treaty claim, as the claimant relied on both the Energy Charter Treaty and the Greece-Georgia Bilateral Investment Treaty. Georgia objected the application of the Energy Charter Treaty, as Georgia did not ratify the Energy Charter Treaty when the events happened. Now let us examine the findings of the tribunal. The tribunal upheld the Energy Charter Treaty and the Bilateral Investment Treaty jurisdiction in this case. ECT jurisdiction upheld, because the dispute related to ongoing effects of expropriation and it was a post-ECT conduct. Bilateral investment treaty jurisdiction also confirmed as investment and nationality criteria were satisfied. On merits, the tribunal found that the termination of GOPC's concession constituted an expropriation and Georgia failed to provide compensation and did not follow the due process. Georgia's arbitrary conduct and disregard for contractual rights violated the fair and equitable standard. As expropriation was confirmed, it was held that Georgia breached its obligations under the Energy Charter Treaty, Article 13(1), which is the protection against expropriation. The second dispute is that of Nykomb's Synergetics Technology Holding AB versus the Republic of Latvia. Let us examine the factual background of the dispute. In 1997, Latvenergo, the state-owned power purchaser, and Window, a Latvian company wholly owned by Nykomb, Sweden, entered agreements for construction and operation of power plants in Latvia. Under the agreements, Latvenergo was to purchase surplus electricity at double tariff, twice the average power sale tariff approved by the Public Utilities Commission. When Window's plant became operational in September 1999, Latvenergo refused to apply the double tariff, citing a new energy law enacted after the conclusion of the contract. Instead, Latvenergo paid only 75% of the average tariff, and Window alleges that this prevented it from operating profitably. Let us examine the claims by Nykomb. The first claim was based on expropriation, and Nykomb argued that Latvia's refusal to pay the double tariff amounted to a regulatory taking. The second argument was based on discrimination, and Nykomb argued that Latvia acted discriminatorily as other companies received the double tariff. Latvia defended that the entitlement to the double tariff ended under the new energy law, which applied uniformly, and Window was therefore only entitled to 75% of the average tariff. Let us examine the findings and outcome. The tribunal found no expropriation in this case. There was no taking or interference with Window's assets, management, or shareholder rights. Therefore, the tribunal held that there was no expropriation or measure equivalent to expropriation under Article 13(1) of the Energy Charter Treaty. On the other hand, discrimination was established. The tribunal found that Latvia breached Article 10(1) of the Energy Charter Treaty by discriminating between power producers. The state offered the double tariff to other companies without valid justification for a different treatment. The outcome was that the tribunal held Latvia liable for discriminatory treatment under the Energy Charter Treaty. No compensation was awarded for expropriation. but breach of fair and non-discriminatory treatment was confirmed by the tribunal. The third dispute for our discussion today is Petrobart Limited versus the Kyrgyz Republic. Let us examine the factual background of the case. Petrobart Limited of Gibraltar and KGM, a Kyrgyzstan-owned company, entered into a sales contract for the purchase of 2 lakh tons of gas condensate. Petrobart delivered 5 shipments but was paid only for the first 2 shipments. While Petrobart sought recourse in domestic courts, the Kyrgyz government undertook restructuring of the oil and gas sector, and this include privatization of KGM and transfer of its asset to a new company without transferring liabilities, including debts onto Petrobart. Intervention by the Vice Prime Minister, who requested a stay of enforcement of Petrobart's court judgment. And before enforcement could resume, KGM was declared bankrupt, which nullified Petrobart's ability to recover the payment. Let us examine the claims, findings, and the outcome. It was claimed that there was a failure to provide fair and equitable treatment by transferring asset to a new company and frustrating Petrobart's ability to collect its debt, which violated Article 10(1) of the Energy Charter Treaty. It was also claimed that improper state interference in judicial proceedings, undermining the enforcement of a final court judgment, violated Article 10(12) of the Energy Charter Treaty. The tribunal found the Kyrgyz Republic liable under the Energy Charter Treaty as the unfair and inequitable treatment through the restructuring and asset transfer harmed the creditors, and interference with judicial independence, which violated due process and effective protection guarantees. The tribunal held Kyrgyzstan in breach of its obligations under Articles 10(1) and 10(12) of the Energy Charter Treaty. The Sevilla Court of Appeal in Stockholm in 2007 upheld the arbitral award, rejecting Kyrgyzstan's challenge. The next dispute for our discussion today is Amto versus Ukraine. Let us examine the factual background of the dispute. Amto, a Latvian company, invested in Energo Alliance Limited, an Ukrainian company involved in electricity trading. Energo Alliance had supplied electricity to several state-owned enterprises and accumulated significant receivables from them. Ukrainian authorities and courts allegedly failed to enforce payment of these debts. Amto claimed that Ukraine's actions and omissions harmed its investments in Energo Alliance, violating protections under the Energy Charter Treaty. Amto claimed the violation of Article 10(1) of the Energy Charter Treaty, fair and equitable treatment, and full protection and security. They also pointed out a failure to ensure effective means of asserting claims and enforcing rights, and also claimed indirect expropriation through state inaction and interference with judicial enforcement. Ukraine raised a jurisdictional objection, and according to Ukraine, Amto did not qualify as an investor under the Energy Charter Treaty, as its shareholding in Energo Alliance was too small to amount to a protected investment. The tribunal found that shares and associated rights in Energo Alliance were covered under Energy Charter Treaty Article 1(6) and therefore investment existed. The tribunal also found that Amto met with the nationality test under the Energy Charter Treaty Article 1(7) and therefore qualified to be an investor under the Energy Charter Treaty. On merits, the tribunal found that there was no violation of fair and equitable standard treatment, as Amto failed to demonstrate any denial of justice. The tribunal observed that Ukraine's judicial and administrative inefficiencies did not amount to denial of justice or bad faith. The tribunal interpreted the full protection and security standard as legal security, not physical protection, and observed that Ukraine's conduct did not breach this obligation, as the investor retained ownership and control. The tribunal held that there was no expropriation. The tribunal dismissed all the claims and ordered Ukraine to pay a portion of arbitration cost, recognizing the respondent's partial procedural responsibility. The next dispute for our discussion today is Plama Consortium Limited versus Republic of Bulgaria. Let us examine the factual background of the dispute. Plama Consortium Limited from Cyprus purchased an equity interest in Nova Plama, an oil refinery in Bulgaria, and alleged that Bulgaria interfered with the operation of the refinery. Claims were brought under both the Energy Charter Treaty and the Cyprus-Bulgaria Bilateral Investment Treaty. In the jurisdiction decision, the tribunal retained jurisdiction under the Energy Charter Treaty but rejected jurisdiction under the Bilateral Investment Treaty. Bulgaria argued that Plama obtained government consent through misrepresentation. When approving the share purchase, Bulgaria believed two major commercial companies owned Plama, while in fact it was controlled by a single private individual who concealed this fact. Let us examine the findings. It was found that Plama's conduct violated Bulgarian and international law. The tribunal emphasized that the Energy Charter Treaty protects only lawful investments consistent with the rule of law. Citing Incesa versus El Salvador and World Duty Free versus Kenya, the tribunal invoked the principle no one can benefit from their own wrongdoing. Regarding the good faith obligation, the tribunal observed that investors must disclose relevant and material information to host states, especially for approval of investments. The tribunal held that Plama's investment made through deceit was not entitled to the protection under the Energy Charter Treaty. Let us examine the findings on merits and the outcome. On merits, the tribunal found that even if protection applied, Plama's claims would have failed because the refinery project was high risk and commercially unviable, and the losses were not attributable to any unlawful acts of Bulgaria. The outcome was that the tribunal dismissed all claims under the Energy Charter Treaty and found that Plama's investment was unlawful and made in bad faith, disqualifying it from the treaty protection. Let us conclude our discussion. Across all the selected cases, tribunals have clarified the contours of investment definitions, fair and equitable treatment, and expropriation standards within the energy sector. Early awards such as Nykomb and Petrobart demonstrated the Energy Charter Treaty's role in safeguarding investors in transitional economies, while Kardossopoulos expanded the understanding of state responsibility for expropriation and continuity of treaty protection. Conversely, decisions like Amto and Plama emphasized the limits of treaty protection, reaffirming the need for good faith, lawful conduct, and clear proof of state interference. Collectively, these rulings underscore the Energy Charter Treaty's dual function as both a shield for investors and a framework respecting regulatory autonomy of states. Let's see what's coming up. The upcoming session will explore state withdrawals from the Energy Charter Treaty, states' ability to regulate in the public interest. This discussion will examine the growing trend of Energy Charter Treaty withdrawals, their implications for energy transition policies, and the balance between investor protection and regulatory sovereignty in addressing climate and public interest objectives. Thank you.